Typically, anyone convicted of a drinking and driving related offense in Ontario is subject to a minimum 1-year driving prohibition and a minimum 1-year license suspension under the Highway Traffic Act and through the Ministry of Transportation, or MTO. In addition, after their suspension, they are required to use an ignition interlock device on their vehicle for at least a year. This is a device that attaches to the vehicle ignition and reads one's blood alcohol concentration when they blow into it. If it detects alcohol, the vehicle won't start. Now, the MTO offers something called the Reduced Suspension with Ignition Interlock Conduct Review Program. This program allows drivers convicted of drinking and driving to reduce the length of their suspension, as well as the period they are to use the ignition interlock. Of course, there are a number of requirements to be eligible for this reduced suspension, and there are several program streams available to offenders depending on their eligibility. For first-time offenders, the stream that needs to be looked at right away after being charged is Stream A. If the person charged is eligible under this stream, they can reduce their driving prohibition and suspension to 3 months and reduce the period with the ignition interlock to 9 months. This is obviously much better than the standard penalty of 1-year license suspension, followed by a minimum 1 year with the ignition interlock device in their vehicle. However, the issue with Stream A is that in order to be eligible, the accused has to plead guilty and be convicted within 90 days of the offense. This creates a significant time pressure on the accused to make a decision with respect to whether they wish to fight the charge or quickly plead guilty. For someone facing a DUI-related offense, it is important to retain and consult with a lawyer right away. The accused needs a lawyer to quickly obtain disclosure of the case from the Crown Attorney's Office and determine right away whether they have any defenses that would warrant fighting the charge and taking it to trial, or whether the case is one where the recommendation may be to plead guilty to obtain the significantly reduced license suspension available under Stream A.